Okay, we're on.
Hello and welcome to the Charity and Security Network's online discussion of counterterrorism measures and issues for principled humanitarian action. We hope that we'll have a lively and informative discussion. This is a difficult topic because the gray areas in the law are so broad. It makes it very difficult for charities and humanitarian organizations operating on the ground to always know exactly what might be permissible under what authority and what might not be. For that reason, we're unable to do the traditional know your rights approach to the law kind of webinar because the rules are not really clear-cut enough. However, there is enough information through international humanitarian law and with the counterterrorism measures themselves, whether based in the UN or in domestic law, to get some idea of the parameters of what is permissible and how to cope with the gray areas. So that will be the focus of our discussion today. Conditions and context change over time, we know, and so here it is 2018, and we want to allow you to look at the issues and think about how counterterrorism measures apply in current operational context. We have two speakers, Jessica Berniski, Law and Policy Associate with the Project on International Law and Armed Conflict at Howard Law School, and Emma O'Leary, Humanitarian Policy Advisor with the Norwegian Refugee Council. And we really appreciate their availability and sharing their expertise today. After their presentations, we'll go into a moderated discussion. At that time, I'll remind you, please submit your questions using the chat function on your screen. And if you would like to make a comment or ask a question in person, please indicate that through the chat and your identifying information so that we can find you on the list of participants and unmute you. And with that, the only other preliminary comment I have is a reminder that this session is being recorded to make available for those who are unable to listen in right now. So with that, we'll start, and I will turn it over to Jessica Berniski from Harvard Law School. Jessica?
Hi, thank you so much, Kay, for the introduction, and thank you to the Charity and Security Network for having me here today and for convening this really important discussion. As Kay noted, I work at the Harvard Law School program on international law and armed conflict, and my research there focuses specifically on the impact of counterterrorism laws on humanitarian engagement. And today, in my remarks, I just want to provide a broad overview of the legal framework and some key trends in counterterrorism, laws and policies that have affected humanitarian assistance. At the outset, I'll note that counterterrorism frameworks represent complex and really nuanced areas of law and policy. I'll be talking about some of these trends and relevant provisions very broadly. So if you have questions, please feel free to share them later in the discussion or in the chat box. But I wanted to note that the information I'm sharing today should not be construed as legal advice. And if you have questions related to your work or that of your organization, I would recommend seeking out legal counsel for specific guidance on these issues. If you'll turn to the next slide, please. So to begin, I want to set the scene by talking about two related trajectories. So first is one that states and international bodies have increasingly adopted laws and policies to respond to threats posed by non-state actors that are designated as terrorists. So at the same time, humanitarian crises are increasingly taking place in areas where designated terrorists are also active. In some instances, these designated groups may actually control territory and access to civilians. These situations have demonstrated the continued need for effective life-saving assistance. And these two trajectories intersect in ways that can also result in sharp tensions or even in direct conflict. Terrorism has long been a focus of the international community dating back to the 1930s, but really in the last decade and a half, we've seen a surge in counterterrorism policies and laws and programming at the international level. And the UN Security Council is one of the key drivers of these counterterrorism efforts. In the years immediately prior to, but also right after the attacks of September 11th, 2001, the Security Council took action to protect states and to deter and punish terrorist acts. And in particular, I wanted to talk about two groups of Security Council resolutions that require states to address the threat to international peace and security that's posed by terrorism. So the first is UN Security Council Resolution 1267 and its related subsequent resolutions, and then also UN Security Council Resolution 1373. So the first group of resolutions I wanted to talk about is related to Resolution 1267. So this line of resolutions requires states to take certain measures to impose a travel ban, an assets freeze, and an arms embargo. This was first focused on the Taliban and Al-Qaeda, and it's since been expanded and adapted to respond to new and changing conditions. It requires UN member states to freeze the funds and other financial assets of individuals and entities who are designated on what's called the consolidated list. This is a risk that's managed by a committee, and it includes individuals and entities that are associated with these groups. And in the second group of resolutions stemming from Resolution 1373, which was adopted in 2001, the Security Council requires member states to develop laws and measures to improve their ability to prevent terrorist acts. So, for instance, these resolutions require member states to criminalize certain acts associated with terrorism, to freeze the funds of individuals who are involved in terrorist acts, to cooperate with other states to share information that could prevent terrorist acts from occurring, and also to put into place criminal penalties for persons who commit terrorist acts. Resolution 1373 also requires member states to refrain from providing any form of support, active or passive, to entities or persons involved in terrorist acts. And it's this notion of support that I will talk about a little bit later in the domestic context, and how certain states have approached that issue and how that can actually affect the provision of humanitarian assistance. So I just wanted to, in shifting to talk about the domestic counterterrorism frameworks, I just wanted to emphasize that in the UN counterterrorism resolutions that I talked about, these contain requirements that are legally binding on UN member states. These don't take effect immediately, though, in a state's domestic legal system. So in giving effect to the requirements of the UN Security Council resolution, states can then tailor the measures to their own domestic context. And in some instances, states can go even further than the requirements that emanate from the UN Security Council in developing their own counterterrorism laws and policies. And in some instances, there are activities that are related to humanitarian aid and assistance that can be criminalized in some contexts. And, often I think another notable trend in the domestic context, as well as, in the UN Security Council resolutions I talked about, is that these frameworks rarely exempt principled humanitarian action from counterterrorism laws and policies. So that's another area that presents some challenges for humanitarian actors. So I want to talk about one particular approach to a domestic counterterrorism legal framework. And I was going to talk about the United States approach to some of these issues because I think it represents a key example of how some states have approached these particular requirements. And also, the U.S. counterterrorism framework is both robust and far-reaching. And so aspects of U.S. law have affected humanitarians in a really broad range of contexts. And there are several aspects of U.S. law that I wanted to talk about. So the first is the criminalization of what's called material support and resources. Other areas of U.S. law that can affect humanitarians is the implementation of economic sanctions. There are also administrative regulations and other legal requirements that emanate from contracts and grant agreements that are reached between the U.S. government and its grantees, which can include humanitarian organizations. So these various aspects of law and policy can all, seek to advance aspects of a state's counterterrorism policy, but that may also have effects on humanitarian assistance. So U.S. law prohibits the provision of what's called material support and resources to a foreign terrorist organization. This is a crime that's punishable by up to 15 years imprisonment. And U.S. law defines material support and resources as, quote, any property, tangible or intangible, or service, including currency or monetary instruments or financial securities, financial services, lodging, training, expert advice and assistance, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, and transportation, except medicine or religious materials. So I read that definition because I think it illustrates the breadth of the U.S. law on this particular issue, and also the very limited exemptions for only 2 items, which are medicine and religious material. So the other aspect of this particular law that I think is noting here is that the United States asserts extraterritorial jurisdiction over the crime of material support. So this means that the prohibition is far-reaching and it can sweep up a really broad range of actors or activities. Also worth noting, the U.S. Supreme Court has addressed the statute in a case that may be well known to some of you, Holder versus Humanitarian Law Project, and it introduced some concepts related to how the idea of material support or resources should be understood. And one notable aspect of that was this concept of the fungibility of aid. And this means that, to the Supreme Court, any contribution to a designated person or organization essentially frees up resources for it to use toward terrorist acts. So even if, as an holder, the contributions were towards humanitarian assistance or peace building activities, those things can actually help further the terrorist aims of a group. Next slide, please. And I think we might actually need to advance it one more. Yes, thank you. The U.S. Executive Order 13224, it blocks property and prohibits transactions with certain designated individuals. It also gives U.S. cabinet officials and government agencies responsibility for determining certain aspects of these sanctions. So many of you who work in this field may be familiar with the U.S. Treasury Department's Office of Foreign Assets Control, or OFAC. This is the office that's charged with administering and enforcing U.S. economic sanctions, including sanctions against terrorists. And so many humanitarians who work in certain contexts may actually come into contact with these sanctions and be presented with some challenges about how to work around them or how to deliver assistance without contravening the sanctions themselves. Next slide, thank you. So the other area of legal obligations that humanitarian organizations can face, particularly in the U.S. context, but also in other domestic systems, is administrative regulations or other requirements related to vetting or screening. One particular way that these requirements can actually also be realized is related to counterterrorism clauses in grant agreements or contracts. So in particular, one U.S. government agency, USAID, requires its grantees to provide certain certifications related to anti-terrorism. And I want to talk about these because they've been a focus of some recent legal cases in the U.S. system. And the current approach to these issues is that the certification really goes a lot further for humanitarians to make these certifications to the U.S. government in terms of what they're saying that they're going to do with respect to material support or what they have done. So this certification requires a grantee to say that for the past 10 years, it has not, and it will take all reasonable steps to ensure that it will not provide material support and resources to designated persons or entities. Grantees also have to take other steps to verify that certain individuals or entities are not included on relevant UN or US lists. So this really takes some of the requirements of US counterterrorism law and applies it directly to grantees who are entering agreements with the US government and then who are required to put into effect those requirements in their work. So I want to just conclude very briefly by emphasizing that, going back to this notion of the 2 trajectories. So states have taken many measures to protect humanitarian assistance and to put support of principled humanitarian action at the forefront of their foreign policy. humanitarian principles, and these include humanity, impartiality, neutrality, and independence. These serve to help enable humanitarian assistance to reach the beneficiaries, including civilian populations in need, as well as those who are no longer participating in hostilities. But at the same time, counterterrorism laws can present certain challenges to and dilemmas for humanitarian organizations to deliver life-saving assistance. In particular, counterterrorism laws like the ones that I identified briefly in my remarks, these can adversely affect the ability of humanitarian organizations to successfully negotiate access and to provide assistance to beneficiaries. And this arises particularly in crises where there are designated groups or entities that are active. Beyond what I briefly discussed here, counterterrorism laws can impose additional obligations on humanitarians, including due diligence requirements, and then I mentioned vetting and screening of local partners. And again, these issues have become really salient in recent years, particularly as many conflicts involve designated terrorists, and they control territory and access to civilians in conflicts, ranging from a range of situations and environments like Afghanistan, Gaza, Iraq, Libya, the Philippines, Somalia, Syria, and Yemen. Also, as I touched on with the material support statute, some states' domestic counterterrorism frameworks passed humanitarian aid and assistance, including the steps that are preparatory to providing that assistance. So, paying fees to de facto authorities who may be designated as terrorists. The states may categorize that as impermissible support, forms of support to the enemy. And as I noted, it's relatively rare for states to expressly exempt from counterterrorism laws principled humanitarian action. And if exemptions do exist in legal systems, as in the U.S. context, they can be quite limited and not provide a sense of legal clarity to organizations who are attempting to provide this assistance. Another aspect of the laws, that I touched on in U.S. context, but in many other contexts as well, is this sense of legal ambiguity. The laws can be written quite broadly, and this leads to a lot of lack of clarity around what's permissible and what may not be permissible. And in some instances, research in this field has talked about this notion of a chilling effect. So the lack of clarity surrounding some of these laws can actually lead humanitarians to perhaps not engage in work in certain areas where the legal risk or the operational risk may be too great for them to operate. So certainly these legal frameworks and these policies can set up really key challenges and dilemmas for humanitarian actors. And, although groups have been looking at this issue for years, I think we're just beginning to understand and scratch the surface of what the evidence of that impact actually looks like. And so with that, I'll turn it back over to Kay, and I certainly welcome any questions or comments you may have in the chat.
Kay, we can't hear you. You're muted.
Oh, I'm sorry. I forgot to unmute myself. Worst mistake. I was thanking Jessica and saying that she provided a good transition for Emma O'Leary, who will present the Norwegian Refugee Council report and recent research on Principled Humanitarian Action.
Thanks, Kay. I think we can already go to the first slide, please. Great. So first of all, thanks to Kay and Andrea and the Charity and Security Network for organising today. As Kay has mentioned, I work for the Norwegian Refugee Council. I'm a humanitarian policy advisor, and my work is really focused on this specific area of the impact of counterterrorism on principled humanitarian action. And it's an area that NRC has had a special interest and put particular resources into for some time now. So thankfully, from my perspective, Jessica has done a fantastic job of describing what's really a very complex legal and compliance landscape with a lot of different grey areas. So she's made my job a lot easier by covering the really difficult side. I'm just going to look at the issue from a more operational perspective. So as Kay mentioned, NRC recently released a report. The report is called Principles Under Pressure. It's focused on the impact of counterterrorism measures on principled humanitarian action. The report is available online. It's currently available in English and Arabic, and we'll have the French translation available shortly. So this is a follow-up to the 2013 NRC and OCHA joint report on the same issue, which is really at the time regarded as the seminal report in this area. But since then, we've had a lot of calls from both governments, donors, and other stakeholders to increase the evidence base for this area. And this report is really an effort to respond to those calls. So the report involved field research, which was carried out in Nigeria, Somalia, and Iraq. And we also completed an online survey with, I think, about 170 respondents there. So while I hope you'll all read the report in great detail, I will take you through some of the key findings and recommendations and give you a bit of an overview of what we found through our research. So I think we can go to the second slide. Thanks. So first of all, I'm going to take a look at sort of framing the key issues that the report deals with. Then I'll look at some of the key impacts that we found. I'll briefly cover some of the mitigation measures and coping mechanisms that we're seeing organizations use to cope with these issues. And then I'll look at some of the report's key recommendations. So I won't kind of go into detail on the legal side at all. As I said, Jessica's already really covered that very nicely. But just to say that the report is really looking at the issue of the fact that on the one hand, humanitarian organizations are legally bound to comply with legislations and sanctions related to counterterrorism. And then we're also contractually bound to comply with donor requirements, which, as Jessica has outlined, often reflect that counterterrorism legislation. And the problem for us arises when designated terrorist groups are parties to a conflict and they're in control of a population which may be in need of humanitarian assistance. We need access to that area. And the designated terrorist group is positioning themselves as, essentially a de facto government. To access areas under their control, organizations may have to pay tax, and they may have to pay expenses to these organizations if they invite them to a meeting or to a workshop. And all of this could potentially be in breach of counterterrorism measures. And as a result, populations in areas under the control of designated terrorist groups may not get access to the assistance that they need. So legal cases involving organizations who have perhaps been accused of breaching this kind of legislation, either criminal or civil cases, are really thin on the ground. There's really only a handful of examples that we can give. And the most recent one, and I'm sure everyone listening will be familiar with the case involving Norwegian People's Aid, who settled recently. And then that's a widely reported case. But really the impact of these cases, despite their small number, has been really, really remarkable. A huge concern for organizations is the reputational risk that's involved when organizations are accused of diversion of aid towards designated terrorist groups. So the issue becomes even more worrying when we consider the wider sphere that we're in now, where humanitarian organizations are under increasing scrutiny. We have a lot of governments and a lot of other interests looking at funding for the sector and asking a lot more questions, and so that in terms of reputation causes more concern for organizations as well. So I think we can go to the next slide. Okay, so we looked at the impact of counterterrorism measures on 3 different levels. Structural, so structural impacts relate to organizations' abilities to adhere to the humanitarian principles. Operational, relating to organizations' decision-making around programs. And then finally, internal, so that relates to issues like access to financial services, compliance, due diligence, and coordination with other organizations as well. So those were the three levels that we explored in our research. So to take them one by one, first of all, so maybe we can return to the previous slide. So to take them one by one, structural impacts. So this was the impact relating to organizations' ability to adhere to the humanitarian principles. So in looking at this area, we clearly saw that counterterrorism measures are not the only constraints that organizations face when operating in complex environments. There are lots of other issues: logistics, security risks, security regulations, but we did find that counterterrorism measures complicate organizations' abilities to operate in these complex environments. So the overarching finding here was that counterterrorism measures prevent organizations from programming on the basis of needs alone, and forces them to avoid certain groups or certain locations. So in contexts like Afghanistan, where 65% of the population is under government control, is in government-controlled areas, this really has a significant impact, because you're looking at a large swathe of the population there outside government-controlled areas. And if the response is confined to those government-controlled areas, large parts of the population will not be able to access the assistance that they need. And there's also a clear impact there on perception as well. If humanitarian responses are confined to government-held areas, non-state armed groups, communities, and so on may perceive humanitarian organizations as partisan. So the case study we used here was that of Nigeria, and so we found a really interesting situation in the northeast of the country there, and we found that the Nigerian government was really using a counterterrorism narrative and the language of counterterrorism to limit the humanitarian response in the northeast of the country. We found that the response was completely confined to government-held areas, very much controlled and constrained by the government. The government argues that areas under Boko Haram control are largely unpopulated, despite humanitarian organizations' estimations of the numbers of people in need in those areas. They sort of accuse organizations who might try to engage with Boko Haram of aid diversion, of supporting terrorism. And these are obviously extremely serious allegations, and this has had a devastating impact on principled humanitarian action in the northeast of Nigeria. And ultimately, it means that populations living in areas under the control of Boko Haram are simply not getting access to the aid that they need. In terms then of operational impact, so this related to impact on program decisions. So the 2013 OCHA and NRC study, which I mentioned earlier, identified lots of different examples of sort of misunderstandings, confusion, and self-censorship around counterterrorism measures. And unfortunately, our research found that little has changed here. Almost half of respondents to our survey said that counterterrorism measures did not provide them with clear direction in terms of their obligations and their responsibilities in terms of counterterrorism measures. And then this confusion created a real climate of sort of fear and self-censorship among humanitarian organizations. So here we took the example of Somalia. That's where we did our field research for this section. And this is the only context where there is a humanitarian exemption to a UN Security Council sanctions regime. The exemption here allows a limited set of humanitarian organizations to work in areas under the control of Al-Shabaab, who are a designated terrorist group, without fear of violating the sanctions. So the exemption applies to UN agencies, to their partners and to organizations with UN observer status, so essentially the ICRC. So this exemption was brought in by lobbying from humanitarian organizations after these organizations saw how the designation of Al-Shabaab as a terrorist group impacted their ability to respond to the famine in 2011. The designation of Al-Shabaab had a real impact, first of all, on the flows of grants into the country because of fear of potential diversion, and it had a real impact on organizations' willingness to operate in areas under the control of Al-Shabaab, again, for fear of falling foul of the sanctions regime. However, 8 years later, the research that we carried out found that organizations were essentially no better placed to respond in Al-Shabaab held areas than they were back in 2011. So Al-Shabaab presents itself really as a de facto authority in its areas of control. It has a well-established system of taxation and checkpoints and so on. And there's huge fear among organizations operating in Somalia about the reputational risk of being involved in even a single incident of diversion. And as a result, organizations are really reticent to use the exemption. And this is compounded by concerns that actually the exemption doesn't really protect them from prosecution. And as a result, they simply believe it's easier to work in government-held areas. Now, at one stage, organizations did, as a group, try to push for an expansion of the exemption. They tried to alter the exemption so that it was applying to activities, humanitarian activities, rather than to certain humanitarian organizations, and that would then allow for a wider scope of organizations to use the exemption. However, when they approached donors with this proposal, they were essentially told, look, you're really fortunate to have access to this exemption at all. Other contexts like Syria don't have access to such a resource. So, essentially don't push your luck. And this really shut down kind of coordinated attempts to develop the exemption into something that was more operationally useful, and really contributed to this climate of don't ask, don't tell, which we see around these counterterrorism measures. And we found that even those donors who are pushing organizations to work in hard to reach areas, so I think it's fair to say that we've in recent years seen some donors really take up the cause of humanitarian access and push organizations to work in these harder to reach areas. They still can't provide assurance that there won't be negative consequences for organizations who do try to work in these hard to reach areas. And there was a general feeling among organizations that, look, even if that really operating in these areas that may be under the control of designated terrorist groups cannot be done without making difficult choices. And if we as a humanitarian organization approach our donor with these dilemmas, they would be very uncomfortable, and we could get ourselves into quite a difficult situation. So that was the feeling. And again, this ties into the don't ask, don't tell environment around discussions on counterterrorism measures. There were also concerns about the level of support that was actually being provided to staff by their own organizations. So when organizations approached their head offices or regional offices and asked for advice on how to deal with these issues, sometimes they received quite an obstructive answer, not an answer that enabled them to carry out their work, not a supportive answer. Sometimes they received no answer at all, which would indicate that there's also a poor understanding of obligations at head office as well as in the field. So finally, we looked at the internal impact. So this relates to issues around financial access, it relates to issues around compliance, due diligence, and so on. So obviously there's a lot to be said here about the sort of explosion in terms of the area of compliance in recent years and the growing compliance requirements that donors are imposing on organizations. But our main focus in the report was on the issue of access to financial services. So obviously, humanitarian organizations are not the only ones who must adhere to counterterrorism legislation. Banks must also adhere to this kind of legislation and regulation. And as in recent years, we've seen issues around enforcement actions increasingly arise against banks for things like anti-money laundering violations. We're seeing banks have less and less appetite for risk, and they're taking an increasingly conservative approach to dealing with humanitarian organizations, who obviously for them are a high-risk, low-return customer. This conservative approach was somewhat encouraged by Recommendation 8 from FATF, the Financial Action Task Force, which the body which, broadly speaking, sets global standards for counterterrorism regulation. So FATF identified non-profit organizations as being particularly at risk of being abused for terrorist financing purposes. The recommendation has since been revised, but we haven't seen that impact in terms of banks being more open to dealing with humanitarian organizations. Obviously, another huge element here is the influence of OFAC and the enormous influence that the US Treasury and the dollar have over the global financial system. That's obviously a huge concern for banks as well. And as a result, they're putting huge burdens on humanitarian organizations in terms of due diligence and the levels of information that they're requiring from organizations before they agree to make things like bank transfers available to organizations. As a result, humanitarian organizations are seeing huge delays in getting money to the field where it's needed, and sometimes there's outright refusal to carry out bank transfers at all. And banks do not need to explain their reasoning when they refuse to provide services to organizations. Our research found that really small and Islamic organizations are very much the most affected in terms of access to financial services. And so smaller organizations obviously tend to have less due diligence capabilities and less compliance capabilities, and then that makes them a more risky customer in the eyes of banks. For Islamic organizations, unfortunately, generally considered by banks to have a greater exposure and greater risk in this area. So they're also disproportionately affected there too. So as a result, what we're seeing is humanitarian organizations essentially being pushed out of the formal banking system. We're seeing increased use of kind of informal transfer services such as Hawala. We're seeing increased use of cash carrying, so humanitarian staff themselves carrying large amounts of cash into countries where they can't necessarily transfer through a bank. And ultimately, you know, this is really increasing terrorist financing risks because of the push away from the more formal, more regulated banking system. And eventually what we could see happening here is banks ultimately dictating where organizations are operating. So a really worrying situation there. We also looked under the internal impact at the issue of sanctions. Obviously, these add massively to the complexities of operating in areas like Syria, Iran, and so on. One interviewee told us that it took her organization 2 years to understand the organization's obligations to US licensing control in terms of its work in Syria. So a huge drain on resources there, and a real lack of clarity around what the obligations and expectations are. So those were the three levels of impact that we looked at. So we can move on to the next slide now. So we looked briefly at some of the mitigation measures and coping mechanisms that organizations use when they try to deal with counterterrorism measures. So the first one was the use of risk management. So this is essentially the use of different types of internal systems to try and mitigate the risk of breaching counterterrorism measures, while also ensuring principled humanitarian action. So this has obviously been a huge growth area in recent years, in line with the increase in focus on compliance and due diligence. So in 2015, following on from one of the recommendations from the 2013 OCHA and NRC report, NRC developed the risk management toolkit in relation to counterterrorism measures, which you can see on the slide. That's available freely online, so I'd encourage you to take a look if you're interested. It outlines different tools and methods that organizations can use to ensure that they're in compliance, but also to ensure that they're still complying with their responsibilities in terms of principled humanitarian action at the same time. We looked at the issue of remote management. So, you know, ideally, so here, this is where organizations sort of pull, generally speaking, international staff, but sometimes all staff out of a particular area, and they transfer program responsibilities to perhaps national organizations or national staff. And generally speaking, this is regarded as a last resort, but it's in reality become much more common in recent years, and it's certainly not being used only at last resort level. We're increasingly seeing organizations use this as a kind of a method to really avoid risk or minimize their own exposure to risk by essentially transferring risks onto local partner organizations, which again is quite a worrying development. The issue of humanitarian exemptions. So I've mentioned this previously around Somalia. So Jessica also obviously mentioned this in her earlier presentation too. So Somalia, the exemption there was really a result of a strong push by the humanitarian community, and they clearly saw the impact of the sanctions on their work, and they were able to establish a clear advocacy position and push for the exemption itself. As I outlined, it's not a perfect exemption by any means, but it did. It did represent a significant achievement for the humanitarian community there. And since then, we've seen really no strong push for organizations around the issue of humanitarian exemptions. There are a couple of reasons for this, but ultimately organizations have really struggled to establish a joint advocacy position on the issue of exemptions. Some are concerned that it might actually end up limiting humanitarian operations by sort of creating a more strict definition of what humanitarian operations can be. So there are some concerns there, but ultimately it is an area that needs to be explored further, because it is essentially the only means that can legally protect humanitarian operations in situations where there are sanctions. Finally, the area of advocacy. So we've definitely seen that the uncertainty, the self-censorship, the confusion in this area of dealing with counterterrorism measures has really stifled joint advocacy and coordination on these issues. Organizations are very slow to share information between one another, and therefore they really struggle to develop joint positions on these issues. We have seen strong advocacy in some areas, the area of de-risking and financial access being one, with Kay and her colleagues being very much to the forefront there. The issue of de-risking is perhaps one that is somewhat easier for organizations to talk about. It's less controversial, it's less touchy, it's less sensitive than an issue like engagement with non-state armed groups. So that's an area where we also need to do more work. So we can maybe move on to the last slide. So I'm not going to go through all of the recommendations. There are 10 or 11 in the report, and as I said, you're very welcome to read those and go through them. Ultimately, most of the recommendations deal with the need for increased transparency and dialogue around this issue. We don't question the need for counterterrorism, or the mandate that states have to introduce this kind of legislation. For us, it's really about the need for balance when this kind of legislation and these measures are introduced, and the need to prevent unintended outcomes to ensure that principled humanitarian action and humanitarian space are protected. And so with that, I'll finish up and I will hand back to Kay.
Thank you so much, Emma. It's great to have an update from the report 5 years ago, because so much has changed, and this really helps set the context in which the laws that Jessica talked about are operating. For participants, please use the chat function at the bottom of your screen to ask your questions. And then if you would like to we'll read the question unless you'd like to make the comment in person, and then please indicate that in the chat and we'll find you and unmute you unless we run into technical difficulties. In the meantime, I have a few questions that have come in from registrants and in discussing this among our members. And the first is a question about U.S. guidance that was issued in 2014 by the Office of Foreign Assets Control. What is humanitarian assistance, and what is the effect of that guidance? I've heard people at Treasury refer to it as an exemption, but it's not really an exemption. It's very general guidance, and I'd like to hear your comments on both the legal and practical effects that guidance may have and what it might indicate about U.S. enforcement policy.
Sure, I can jump in on that, Kay. This is Jessica. So I think one of the challenges with the guidance that was issued in 2014 by OFAC and some earlier statements that were made in the context of the Somalia famine dating back to 2011 were attempts by the U.S. government to provide reassurance to humanitarians or to issue statements of policy that they would not necessarily focus on the activities of humanitarian organizations in certain contexts. I think that the challenge with this, as you alluded to, is that these forms of guidance or these statements do not provide they don't carry the weight of law, and they don't provide assurances, clear legal assurances to humanitarian organizations that they can engage in certain types of activity and they won't be prosecuted. I think on one hand, the U.S. government does not seem to have gone after organizations in these contexts, but again, it fosters this sense of uncertainty and ambiguity about what, in the U.S. context in particular, how it approaches these issues and how it looks at the activities of humanitarian organizations with respect to counterterrorism measures.
Anything else on that, Emma? Okay.
Yeah, I think Jessica's given a really comprehensive answer there. Yeah, I would just add that, at a broader level, the issue that we see with the existing exemptions is really that they're not carefully worded enough. They're not operationally applicable or useful, and while we do, one of the recommendations we give in the report is that we encourage governments to include exemptions in sanctions regimes, but we stress that they need to be worded and applied correctly to ensure that they do limit the impact of the sanctions.
Okay, the next question I have is something that we hear discussed a lot, which is screening beneficiaries and how against terrorist lists, and how that is that something that's required by CT measures? Is this even permissible, or as under international humanitarian law, if aid is supposed to be based on need alone? And many organizations have drawn a red line saying that they will not screen beneficiaries against terrorist lists. But I guess is this something that appears to be an area of confusion? And I know we can't give a clear black and white yes/no answer, but your comments on that would be appreciated.
Yeah, Emma might have more to say on this, but I will just briefly note that, I think this is an area, as you said, Kay, that for some organizations, they've seen this as a red line, as compromising humanitarian principles to screen ultimate beneficiaries. But I think that it's certainly, as with many aspects of counterterrorism law, still an area of ambiguity. And I think organizations are taking different approaches to how they're responding to that ambiguity.
Yeah, I fully agree with Jessica. I mean, this is a really difficult area for many organizations. It's of course a red line for most organizations. We select our beneficiaries on the basis of need alone, as we're fully mandated to, and as we're expected to by many donors. There is certainly an increasing concern that some donors may be requiring or may be implying or may have worded grant agreements in such a way that vetting of beneficiaries may be required. And it's really a grey area, and it's one that I think organizations need to kind of take hold of a bit more. And it's one that we need to do probably some proactive advocacy with those donors on. I think in many ways the kind of don't ask, don't tell attitude applies here. I think their assumptions are made among organizations on one hand that are not necessarily raised with donors and then actually might turn out to be incorrect. So it really is one of those areas that there needs to be more open dialogue on and potentially renegotiation or rediscussion of those clauses where necessary.
Okay. I have a question that's come in for Emma. Did your research find that wire transfers to the fields affected U.S. organizations more than non-U.S. organizations, or is it about the same? Or was your research able to determine that?
Sorry, I had myself on mute. That's an interesting question. I'd say we didn't, in our research, we didn't particularly split between US organizations and non-US organizations. I mean, certainly the impact of dollar transactions and anything that went through the US in those terms was, those were clearly more sensitive than others. So the impact there was clear. In terms of whether US organizations themselves were more affected, I couldn't really comment because we didn't have, that wasn't one of the aims of our research really in terms of what we looked at, but certainly clearly dollar transactions are more affected and more of a concern for organizations than those in other currencies.
Okay. There's another question that's come in about, were you able to tell what were the most commonly used methodologies for informal transfers? You mentioned cash carrying, use of hawalas, and did you get a sense of how widespread it is?
Yeah, certainly use of hawala was, I mean, hugely widespread, particularly we looked at parts of Syria where obviously the banking system has collapsed, and it was, it was essentially the only means of getting money from one place to another. So I mean, the use there was absolutely across the board. And I'd stress as well that we're not raising hawala as a concern kind of across the board. It's obviously, it's been used for a very long time. It's well established in many cases and well regulated in some areas. The issue really arises when you've got a conflict area and you've got then an unregulated transfer system. You could, of course, potentially run into risks there. And there's also obviously tied to that issues around pricing and how expensive hawala can be in certain areas because the market can be quite tight. Cash carrying was raised to us. I couldn't comment on how widespread it was, but we did have several interviewees who mentioned that it had been used by their organization, but I couldn't comment on how widely that was.
We found in our research last year that for U.S. charities operating internationally, in our survey, 42% said they had at some point been forced to carry cash. So that is a very apparently widespread tactic that organizations have been forced to use, and certainly does create more risk. I wanted to ask another question that's come in about the nature of neutrality. It's one of humanitarian principles, and where the focus of neutrality needs to be in terms of, is it beneficiaries, with selecting where you go, with donors, with partners you choose? What is the primary focus of neutrality?
Sure. So neutrality is, a principle of humanitarian action. It generally means that organizations, are not to take sides in hostilities or in other, controversies related to, the hostilities, on the grounds of ideology or race or religion or political aspects. And so, I think, that's one of the areas of tension, certainly, between counterterrorism measures and the humanitarian principles, that in some respects, the requirements that counterterrorism frameworks place on humanitarian organizations, I think for some organizations, this represents a conflict, between upholding the law and meeting the humanitarian principles that guide their operations. So with respect to neutrality, impartiality, independence, some of these requirements really in a broad way, like related to screening or vetting or providing information back to donor governments, can undermine those principles and also, in turn make it more difficult for organizations to operate in these contexts and to, be successful in terms of their negotiations or their outreach to parties to the conflict.
Any further comment on that? I'd like to follow up with a last question about advocacy, the point that Emma brought up, and how that there is a need for greater clarity in guidance from government and in rules, and for greater respect from the security side on the provisions of IAHL. And I'd like to ask for any suggestions on where people can find forums to engage in advocacy. Do we need to create those? Are there existing places people can go to help push for a better balance between security and international humanitarian law?
Thanks, Kay. I think there are there's a fair variety of different places that organizations can currently go to share information and to try and develop joint advocacy positions. I mean, we've, at country level, you've got the different INGO forums in several areas now. You've got access working groups as well, which are also useful forums for discussing these kind of issues. At the global level, you've got the EASC subsidiary bodies, and then, obviously we've got other areas like the UN Office for Counterterrorism and so on. So, I mean, what we need to do as humanitarian organizations is kind of take responsibility for this a little bit, and recognize the fact that we haven't been particularly good in the past at developing joint advocacy positions, and that has weakened the ability of the friendlier governments, because there are governments who are interested in this area and who are willing to push and to promote our positions and to help us in our advocacy, but they struggle to do so because we haven't given them clear positions from our side. So we really need as a community to step up and to try and make more of an effort to share that information and come to agreement on these positions, because it's very difficult to make progress until that's done.
All right, well, the Charity and Security Network would be very interested in follow-up discussions about finding ways to do that. We have worked on legislative proposals and proposals to Treasury in the U.S., but which have not gone forward in terms of changing the law itself. The U.S. is very stuck in the kind of don't ask, don't tell policy mode, but we would be very interested in working together, focusing either on the UN with friendly governments and others, and following up. So for participants who are interested in that, please let us know, and we'll see what follow-up we can pull together. Could we get the last slide? I wanted to remind people that back in 2012, the Charity and Security Network published a report that is still fairly relevant, Safeguarding Humanitarianism and Armed Conflict, that reviewed U.S. counterterrorism laws and a detailed review and explanation of international humanitarian law as it applies in this context, and analyzes the areas where the two don't really match up, and suggested changes, and suggested that IHL be used as a resource by governments for resolving issues that come up when there are security concerns in areas where humanitarian aid needs to be delivered. So that's another resource for people to draw on. And like to conclude now. We've hit the 1 hour mark, and thank our speakers for their work and presentations, and thank everyone for listening in and submitting your questions, and hope that we'll hear from you about ways that civil society, and especially those concerned with providing humanitarian assistance to the many, many people in need around the world, can work together further to try to narrow the gray areas and provide more operational space for principled humanitarian action. So thank you, everyone.